The Indian judiciary is in news again. It has been in news for the past few days, and primarily because of the challenges that it is facing. Whether it is regarding the removal process of Justice Yashwant Verma, the corruption laden that the charges have been made against him, or regarding the today's newspaper, the article in the Hindu which mentions the pendency in the Indian judiciary system. My name is Ankit Kaur. In this video, we'll try to understand what are the various causes behind the pendency in the Indian judiciary. At the same time, we'll also try to understand what steps can Indian government take to resolve this pendency. Now, this article that is present in the Hindu basically highlights that the pendency in the Indian judiciary has been increasing. It has reached to an all-time high of 5 crore plus cases pending at the different levels of the court, that is at a subordinate level, high court level, and also at a Supreme Court level, with the total pendency mark now crossing 5 crore plus cases. Now, this is an alarming situation because the pendency goes against the basic principle of the Indian judiciary, which believes in the speedy justice. Not only it is the basic principle of speedy justice, but it is also important to understand that right to speedy justice is also a fundamental right that you and me have. This was finalized in the Husainera Khatun versus Secretary of Bihar case. So, a pendency is not only a legal challenge, but it also became a fundamental right issue and a constitutional issue as our right to speedy justice is being denied. Through this video, we'll try to understand what are the various causes behind the pendency. And the first major cause behind the pendency that we can understand is basically due to the fact that government is a compulsive litigant. Government is a compulsive litigant. What do we mean by that? That government is a compulsive litigant. Now, it has been observed that the government is on the side in 50% of the cases that are pending. Meaning thereby, of all the cases that are being pending, government is on one side on 50% of them. So because of government being a compulsive litigant, there is high pendency in the Indian judiciary. The second reason that has been highlighted from various judges to the Law Commission reports to various committees, they have pinpointed one single thing, that is inadequacy. Inadequacy that is present in the number of judges. The number of judges that we have are inadequate. The sanction strength, listen to it very carefully, the sanction strength allows 19 judges per million population in India. 19 judges per million population. Only 19 judges per million population are sanctioned in India. And what is the reality? Because of the vacancies, which is the third point, because of the vacancies of judges, which is seen at the high court and at the subordinate court level, at the high court and at the subordinate court level, because of the vacancies, the sanction strength, which is 19, which is inadequate, is falling to around 17 judges, which has been mentioned in the article itself. What has Law Commission recommended on the same? The Law Commission has recommended that India needs at least 50 judges per million population. 19, the sanction strength is way less, and the actual realization is around 17 to 18 judges. This clogs the judicial system, and this is one of the biggest reasons behind the pendency. Now, when we compare ourselves to the peer like that of China, China has a much better ratio when it comes to per million population. Or that of US, they also have a very better ratio. For example, the US, the ratio is around 100 judges per 11 million population. China, it is about 50. So our peers are doing much better when compared to that of India. In India, inadequacy of judges marred with the problem of vacancy, complicates the issue further. But the problem does not stop here. What is the next reason that highlights the pendency in the judges or pendency in the judiciary? Basically, is what we call as lack of judicial impact assessment. A lack of judicial impact assessment. What is this? When a new law is formulated, we hardly see that there is any consultation with the judiciary. Now we all know that lawmaking is a prerogative of the legislature. But when the judiciary is not consulted, or there is no mechanism for the consultation with the judiciary, it has been observed that whenever a new law comes in, it leads to a lot of litigations. So, lack of judicial impact assessment of a new law which is being passed further complicates the issue of pendency, because a new law will lead to more number of cases being filed. So this is also problematic. A lack of judicial impact assessment leads to increase in the number of cases that are pendency before the Supreme Court or the High Court or even at a subordinate court level. Another issue that has been highlighted behind the pendency is basically the sittings or the number of days for which the different tiers of judiciary meet. For example, the Supreme Court usually meets for around 193 days. Between 190 to 200 days, we have taken approximately 190 to 200 days. 193 days, the Supreme Court sits in. The High Court sits in for around 210 days. And the subordinate courts sit in. The subordinate courts sit in around, or the district courts sit in around 243 days. Now, judiciary or the judicial process, judicial recourse, is a 24/7 activity. Because if an innocent is basically tried, an innocent has to serve amount of time behind the bars, it is basically a violation of his rights or the fundamental rights that we have. Now, the inadequacy in the number of sittings that is seen at the different levels of the judiciary also basically increases the pendency rate. Another thing that is associated with this is basically the disposal rate. The disposal rate of the cases. The disposal rate of the cases has been extremely slow. Now, this differs from one court to another, and it differs from one judge to another. But the average disposal rate in India is slow, and this complicates the pendency matter in the judiciary. The case disposal rate in India is on an average, very low. And this is one of the leading causes behind the pendency in the cases. Now, the next issue that we basically get to know is basically the level of education. The level of education also basically is sometimes leading to pendency in the judiciary. For example, this article suggested that the pendency is more in case of civil cases and less in case of criminal cases. Normally, you and me will believe that the pendency will be more in the criminal cases and it takes years to resolve a criminal issue. But the article with the data has given out and pointed out that the pendency in civil cases is extremely high. And it has been observed with the level of education. For example, in Tamil Nadu, where the literacy level and education is high, the number of civil cases per 1,000 population goes around to 12, while that of in Bihar or Jharkhand, it comes down to around 0.5. So this also complicates the judicial process. That is, though it is well intended because people are more aware of their rights, but this is also one of the leading causes behind the pendency in the Indian judiciary. Some scholars have also highlighted the other issues, which basically is related to the adjournment culture. It is related to the adjournment culture that is being followed in the judiciary across different levels. That adjourning the sessions, adjourning the sittings or the cases. And then another issue is basically that of reservation of judgments. Reservation of judgments is also highlighted that it is one of the leading cause behind the pendency in the judiciary. The adjournment culture and the reservation of the sentences or the judgment also leads to pendency. And last, but certainly not the least, the whole system is clogged by the fact because of the unscientific process through which the legal reforms or legal investigation is being done. There is no timeline. This article also points out that there is no timeline to record the statements of the people who are involved in the case. There is no timeline when these people will record their statements, when there will be availability of the information regarding the same. And the criminal process in India is basically facing the issues of unscientific investigation. Now, judiciary can only resolve a case when they have credible evidences. And when this evidence collection or the legal process or the investigative process, if it is unscientific, it will become very difficult for the judiciary to pronounce anyone as guilty or anyone as innocent. And this leads to pendency. This problem will lead to nothing but what we call as pendency in the Indian judiciary. This is also one of the reasons behind the low conviction rate. As you might have seen in various videos or you might have read in various newspapers that sometimes the criminals have been left or they have been scot-free because of the lack of ability of credible evidence. Because there was no credible evidence that was found, and in the paucity of the evidence, the criminals have to go scot-free. So these are the cases which are basically causing pendency in the Indian judiciary. Then we also need to understand what are the possible solutions from the same. How can we basically resolve the problem of pendency in the Indian judiciary? The first thing that has been recommended by the Law Commission also and through various judges is to fill the vacancy. When you will fill the vacancy, it will solve much of the problems. That is through all India judicial services. By introducing all India judicial services, you can solve a majority of problems in the Indian judiciary regarding the vacancy. And this all India judicial services will also ensure that the judiciary attracts the best talent. Judiciary attracts the best talent. So the best talents will be attracted to the judiciary, and thus we can ensure that the quality of the judiciary will also improve. This is what we need, all India judicial services. Second, there is problem with the judicial infrastructure. There is a problem with the judicial infrastructure. Now, what do we need? We need a national judicial infrastructure authority. We need a national judicial infrastructure authority. What is the need of the hour? This was proposed even by the ex-CGI of India, that we need a national judicial infrastructure authority that will look into the infrastructural issues that the judiciary is facing. For example, the spending of GDP, the spending on judiciary as a percentage of GDP is extremely low. It comes around 0.1% of the GDP. There is a need to increase the same. And when we increase the funding to the judiciary, we need to channelize it through the right medium, and for that we need a national judicial infrastructure authority that will solve the infrastructural bottlenecks that might be present in the judiciary and might be clogging the cases. There is a need to what? There is a need to introduce scientific management. Scientific management. Already the Supreme Court has taken the lead. Already the Supreme Court has taken the lead in the form of integration of AI for the matter of case management. This will further scrutinize the process and also streamline the same at the same time, ensuring that the judicial delays can be decreased. Now we have seen that there is more pendency in the civil cases. So what do we need? We need alternative dispute resolution mechanism. ADR mechanism. The need of the hour is alternative dispute resolution mechanism. When you will have alternative dispute resolution mechanism, this will lead to a system that even if for supposedly civil cases, a person has to first go through you can make it mandatory that when a civil case is involved, the person has to mandatorily go through the pre-mediation or pre-litigation. They have to go for alternative dispute resolution mechanism in the form of mediation, in the form of arbitration, in the form of basically pre-mediation trials they have to go for. So this alternative dispute resolution mechanism will decrease the pendency. They can choose to arbitrate among themselves, they can choose to mediate among themselves, and this will decrease the pendency on the judiciary. And this will particularly work for what we call as the civil cases, where the pendency is more. So this is what we basically need. We can also introduce the concept like that of judicial impact assessment, such that the judiciary is keeping in look when basically a law is being formulated. This will ensure minimum judicial burden once a law is passed. If all these reforms are basically implemented, if the vacancies are switched into, if we can follow the process of what we call as e-courts, we have already embraced it during the COVID. If we can follow the same of e-courts, this will reduce the burden on the judiciary and it will clog the problem. It will solve the clogging of pendency of cases in the judiciary. Justice is the basic necessity, and justice is the most important thing that is also mandated through the fundamental right of the Indian Constitution under Article 21. So judiciary needs to incorporate these systems such that it can perform the basic function for which it has been given the responsibility for and restore the public trust. Which in some cases, which today is a little bit shaking because of the evidences of corruption or the pendency or the problems with the collegium system that have been observed in the judiciary in the recent times. These reforms have already been submitted by various committed law commission and even by the ex-judges at the various level of Supreme Court and High Court. So these reforms need to be implemented at the earliest such that the problem of pendency in the judiciary can be solved. I hope now you have a better understanding regarding why there is a pendency in the Indian judiciary and what are some steps that can be taken regarding removal of this pendency in the Indian judiciary. Thank you.